All right, welcome to the House Judiciary Committee this Tuesday afternoon, March 31st. And we have a few things we're going to look at today. We're going to start with S218, a high-level flyby, drive-by. This is a bill that we dealt with a bit last year, and it's changed some, and it's just being run by us, and it has to do with chloride or salt bill. Also not on the agenda, but H657, we need to close the loop on that bill that we did a drive-by a week and a half or so ago. We'll do that second, and then we're going to go to the home and land improvement fraud. We do those two things. So over to you, Legislative Counsel O'Grady.
Good afternoon. This is Mike O'Grady with Legislative Counsel. I am going to share my screen and put up on the screen S218 as it passed the Senate. You can find this on House Environment's webpage. Sure what happened. There we go. So, as the chair just referenced, you looked at most of this bill last year in H86. It was also S29. It was also added to H319, but it ultimately did not pass both bodies, even though each body passed it independently in the different bills. So what this program does is it is trying to address an issue with chloride contamination of the state's waters. As I think you have all heard over your time here, the state has to meet water quality standards. It has to go out every 3 years and determine whether or not state waters are meeting water quality standards. If they are not, the water has to be designated as impaired, and there has to be a plan that's adopted to clean up those waters. Currently, there are 9 waters that are impaired due to chloride, mostly in Chittenden County, but not just in Chittenden County. The latest is in Franklin County. And what would a plan do? What would the state require in order to bring water into compliance with the water quality standards? Well, it would regulate how chloride, how salt is applied, because when you look at the sources of chloride in the impaired waters, it is almost entirely from the application of salt for chloride products for winter de-icing and for summer dust control. And it's municipal roads, state roads, private impervious surfaces that are all contributors of that chloride. So what this program S218 does, it establishes a voluntary program at the Agency of Natural Resources for the certification of commercial salt applicators who will be instructed and certified in best management practices that will regulate or control the use of chloride, salt for winter de-icing and summer dust control, with the caveat that it is intended to maintain safety while reducing the contribution of chloride to the state's water. When a commercial applicator and also a municipal applicator is trained, they receive a legal benefit. And that legal benefit last year in H86 was immunity from suit. It just said a commercial applicator applying according to the best management practices is immune from suit if the alleged harm is from failure to de-ice or other issue from snow, and the applicator was applying according to the best management practices. So there were advocates who did not support the immunity from liability. Instead, they proposed an affirmative defense instead of immunity from liability. And that is what was in the Senate passed version. And that is what is in S218 as passed this year. And you can see that affirmative defense language, and the chair asked me to just focus on that component of the bill that is the Judiciary Committee's jurisdiction. So that certified commercial applicator or the owner, occupant, or lessee of the real property maintained by that certified applicator have an affirmative defense against a claim for damages resulting from a hazard caused by snow or ice if the claim damages were caused solely by snow or ice, and any failure to delay in removing or mitigating the hazard is the result of that applicator's implementation of the BMPs. It does not apply if the commercial applicator was grossly negligent or reckless in their disregard of the hazard. And in order to assert that affirmative defense, the applicator has to maintain records of their practices, including the rate, type, and rate of application of salt and salt alternatives, dates of treatment, and the weather conditions for each event requiring de-icing. So what is the difference between immunity from liability and an affirmative defense?
That was my question. Took it from me.
So it's generally who has the burden and how you access or assert either. So immunity from liability can preclude a plaintiff from bringing an action. It's then on the plaintiff to show that the immunity from liability does not apply, either like a blanket immunity, such as legislators have for their speech on the floor, or a qualified immunity, which was what you provided last year in H86. You said they shall be immune if those conditions were met. Plaintiff would have to show that those conditions aren't met in order to be able to access the court and to seek a remedy. And the advocates were concerned that that would freeze those persons that were potentially harmed out of a remedy or out of the courts entirely. What an affirmative defense does, it is something that the defendant argues at the pleading stage, usually the initial pleading stage, when there is a complaint brought against them. In their response to that complaint, in their pleading, they say, yes, that happened. They don't argue that they were a commercial applicator. They don't argue that they applied salt or salt alternatives. They argue that they are free from liability because they met the conditions of that affirmative defense. So why is that a difference? Well, it allows the plaintiff into court. It shifts the burden from the plaintiff to the defendant, and the defendant has to show, based on the facts, that they qualify for the affirmative defense. So the plaintiff is not frozen out of a remedy, is not basically excluded from a court. And the burden shifts to the defendant to show that they qualify for that affirmative defense and they are not liable. So that is the key change from what was in H86 last year for the purposes of this committee's jurisdiction. Burden shifts from the plaintiff to the defendant. The plaintiff still has that opportunity to seek a remedy. The defendant still has that opportunity to not be liable if they can show all the conditions that are required for the affirmative defense.
So I'm an applicator and I make the decision not to be certified. Where does that leave me in the lawsuit world, I guess?
So you don't have that affirmative defense. You won't be able to say if there's a claim brought against you that you are not liable. Then it will be on the facts, and it will be whether or not, it'll depend on the situation, the conditions, and the plaintiff will show that you were negligent. And so that's where the benefit is to the certified applicator. They just have to show that they met the conditions and they will be immune from that negligence claim. You, the non-certified applicator, won't be immune from that negligence claim. And so it's a lower bar. The plaintiff will only have to show you had a duty of care and you failed that duty of care.
What if I kept records as a non-certified that,
Well, that will all go to whether or not you breached your duty of care. And you would then, it will be very fact-based. It will be, the plaintiff will bring their facts, you'll show your facts, and whether or not there was duty, whether the duty was breached and whether there were damages.
so I'd have more to prove. I don't know if it'd even be more. In a sense, I guess I'd have more to prove than a certified applicator, because certified applicator is gonna have, say, just for a number, 3 or 4 criteria. As long as I meet those criteria, I'm good.
Right. Exactly.
And then Karen?
Do we have any numbers on how many, maybe we went over last year? Privately owned applicators are judgments fought against them or lawsuits against them?
I don't have that number, and that would be pretty hard to find considering there's not great recording of that at the Superior Court level. I can tell you how many applicators have been certified in New Hampshire. It's over 700 that are certified annually in New Hampshire. It started out, there were only like 5 in the first year, and now over 700 get certified. And they do so because there was a case that was brought in New Hampshire against an applicator. That applicator had all of the records. They showed that in New Hampshire, it's a immunity from liability. It's not an affirmative defense. So that defendant showed that they met all the conditions for the immunity from liability, and the court dismissed the case. They also determined from video recording that the plaintiff didn't injure themselves in the parking lot or on the sidewalk. The plaintiff tried to cross over a vegetated bushy area, and that's where she fell. And the applicator had no duty to maintain that. So it would probably, even if they had been non-certified, they probably wouldn't have been negligent. But they showed the conditions meeting the eligibility for the immunity from liability, and they won.
This is coming back to me, so thanks for this. I'm like, okay, I remember some of these conversations. I understand the affirmative defense piece of it and that it's being voluntary.
Yes.
This is something like an incentive, you could call it. If you do it, you get this. Maybe I don't use the word incentive, but it's something you get if you choose to do it.
Yeah.
My question is, what are the barriers to doing it? Is there a cost? Is there a fee? Or like, just trying to understand, is it very accessible?
Well,
I don't know if that gets into it in here.
what the bill does is requires A&R to set up that program and to provide the training. They can do that training either through an A&R employee or through a contractor. In either event, they're going to need money. And with most of the bills that are creating new appropriations, there's a contingent funding clause that says A&R is not required to do this if they don't get the funding for it. So it was not funded in the House proposal of the appropriations bill because you hadn't seen this bill. This bill hadn't been in front of the House when you looked at the big bill last week. But now there will be that discussion in the Senate because the Senate did look at it. The Senate put it on its list of things to review in their version of the big bill. And you will have that opportunity in conference to reconcile whether or not to provide funding for the program or not.
Okay, but it's not included in the bill as is.
It does not include that. The bill does contemplate that this program will be a fee-based program, that the applicators applying for certification will have to pay a fee for certification, but that specific fee is not currently in the bill as of yet. There's going to be a recommendation back to you next year on what that fee will be.
From that group doing the work to come up
Right,
with the program.
They're going to come up with the program. They're going to determine whether or not they're going to use an A&R employee or they're going to contract out, determine what the fee will be at that point.
And you're saying it comes back to us, we would weigh in if we ultimately approve it or not?
Yes. As you probably know, your Ways and Means Committee really likes to control the fees.
Yeah.
And so there's this report back to you all, the General Assembly, with a recommended fee to be charged either by the state or by a third party for certification. And then you would have to enact what that fee for authorized.
Thank you. I'm just trying to understand. I know our piece is the affirmative defense, but I'm just trying to understand how people would be able to access it and get it. Yeah.
So there is another part of the bill that's very similar, but you should also be aware of, because it goes to a larger question or issue that's been before this. I know that's been before this committee, and it's the same affirmative defense that's offered to municipal salt applicators. They would not be going through an A&R certification program. They would be trained annually by AOT, because annually road workers are offered training from AOT in what's called the Vermont Local Roads Curriculum. The bill would require the Vermont Local Roads Curriculum to include the BMPs for chloride application, salt and salt alternatives. And then once that municipal salt applicator goes through that training, and they would have to do it annually, they would get that affirmative defense. You'd see page 10.
Has to go through it annually?
They do go through it annually.
State.
Yeah, no, the municipal.
Municipal, right.
Municipal. The state already has a program that they run, and they also have the State Torts Claims Act, which limits their liability. And so they basically, AOT said this is not necessary for them because they already have their own standards, they already have their own controls, and they already have that limited liability. But the municipalities, as you know, have been looking for a broader immunity. This does not give out broad immunity. It's just the same affirmative defense that the commercial applicator would get. Same, they have to be trained. The damages were caused solely by snow or ice. Any failure or delay in removing or mitigating the hazard as a result of the implementations of those BMPs. And they have to maintain records in order to assert the affirmative defense.
Maybe I missed it, but what if there was some sort of issue beyond our control about people being able to get salt or sand and being able to do the job correctly?
So it's not about whether or not you're applying, it's how you apply. So if you don't have a salt or salt alternative to apply, you don't get the affirmative defense because you can't argue that the hazard was caused solely by snow or ice and you were applying the BMPs because you weren't applying BMPs because that you didn't have.
You won't have the defense.
If there's an
You have
absence
to
of
stretch
that,
it because you don't have enough.
right? But in that case, most likely the liability is going to be with the property owner and not with the applicator. If the applicator can't apply because they don't have it, the liability with the property owner. The property owner gets the same affirmative defense if their applicator that they've contracted with is meeting all the conditions of the affirmative defense. So there's no salt or sand or salt alternative to apply. there is no affirmative defense because you can't argue that you're complying with the PNP.
So this sets up the whole program. And it's, takes effect upon passage. But nobody can sign up for it. Because,
Well, A&R has to adopt the rule
yeah, but
for the
there's no fee
program.
yet.
Pardon?
But there's no fee established yet?
There's no fee established, and A&R has time in order to adopt the rules, because as you all know, rulemaking can take up to a year.
Yeah.
And so they have,
So if they need all that time, why would it take effect on passage? Not,
there are a couple of things in the bill that you want to take effect on
Okay.
passage, and that is first, giving A&R their rulemaking authority on passage so that they can go right away to rulemaking it as fast as possible instead of waiting until July or some other future date. There's also a report back on salt piles, municipal salt piles in the state, whether they're covered, whether they're in proximity to a water, whether they should be moved or covered, and what the cost of that would be. There is no mandate to cover. There is no mandate to move. It's just about identifying those salt piles, municipal salt piles that potentially pose a problem and potentially that problem could be solved through cover or movement. A&R largely has that information already. And to give them the ability to put that together quickly and get it to you by December is one of the reasons why it's effective on passage as well.
Any other questions from them? All right, so I guess the question for committee is, are there additional individuals we need to hear from? We want to hear from Adam Krasson or somebody from one of these in cities and towns. I mean, it's similar to what we took up last year. I think you just explain the difference. It's affirmative action instead of immunity. But I'm happy to, what do you think?
the league,
Take one.
I think the league,
Okay, all right.
I think pretty easy.
We can-
For Adams.
Yeah, we'll get into Krasson and we'll get this week. So
Okay.
I'll let Chair Sheldon know that.
Okay.
So I think we're supposed to have Hillary here for a walkthrough of 183. So we'll do 183 and take testimony from Matt Valerio on S183. And then we'll turn to 657.
Good day.
All right, thank you.
May not laugh or.
Stay online. Like, so do we know if Hillary's on her hold?
Accepted the.
We're gonna get it, we'll pass it out. We'll pass it out.
Neither one of them, right? We're getting picked up on both of them.
That's
what I meant to say.
183 and yeah, H 657.
Thank you.
I just printed the amendment out. Printer out there.
All right, but let's do one, yeah, no, we'll get 83 first. Yes, push.
Okay.
Thank you.
So, you can hear from Matt Valerio first. You want to join us, Matt? I mean, it's not a super complicated deal, and we can get your viewpoint, then we'll have Hillary give us the walkthrough.
Sure.
Oh, well, or I guess not. So we'll have Hillary give us a welcome.
Matt, you got voted again.
Do you want to start, Matt, or do you want to go after the walkthrough?
Doesn't matter to me. This is about as simple as it gets, so it won't be long.
Yeah, I think the walkthrough is not going to be too long either, so
You'll be disappointed if we have a lot of questions then.
Kicking Matt when he's down.
Sorry, we're coming from a walkthrough of Senate institutions, so
We're still,
we're running a few minutes.
not a problem. No, this is ours to deal with. Yeah, this isn't a drive by. This, we have jurisdiction on this one.
All right, for the record, Hillary Cheddar Ames for the Office of Legislative Counsel. S-183, talking about home and land improvement fraud. It's really making two changes to existing law. The first is clarifying one of the elements of the current crime to avoid a constitutional issue. Happy to talk more about that, but that's the first kind of change that S-183 makes. And second, it clarifies that the statute applies to contracts and change orders. Change orders are basically a contract modification. They're their own contract, but if you enter into a contract and then later, for house improvements, and you later say, can you also fix the roof on my garage? That might be a change order that changes the kind of work that you're doing under a home improvement or land improvement contract. So that's the preview, the two changes. I will go ahead and dive into the statutory language. So this is 183. The first substantive changes are on page 2. Subsection A are just the existing definitions in statute, no changes there. Subsection B is where we have the first substance of the elements of the crime of home improvement or land improvement fraud. So, two things to say about home improvement fraud. You have to have a qualifying contract, first thing. That's basically what the first part of subsection B says. It can be written or oral, but it has to be a contract for home or land improvement. And there are some amount requirements. So it has to be at least $1,000 if it's a contract with a single owner, or if it's for contracts with multiple owners, it's got to be a minimum value of $2,500. The second part of it, which is where the kind of meat of the changes come, are that the contractor has to knowingly commit fraud in entering into the contract. The statute outlines a couple kinds of fraudulent conduct. The changes that are being made are to the first one. So this statute was passed in 2003, and there have been some changes since then. And the challenge is that the change in 2015 removed some language and changed some language so that instead of criminalizing fraud in entering into the contract, the language read as if it were criminalizing breach of contract. So breach of contract, you say you're going to do something, you don't finish it, you don't do it. A homeowner can pursue a civil suit for a remedy, but that in and of itself is not a crime. And states really can't criminalize breach of contract, but they can criminalize fraud in entering into a contract. So the change that S-183 makes, this is line 13. Well, there's a change on line 7, and then 13 through 21 is that this essentially returns to or uses most of the language in the pre-2015 version of the statute. So it goes from the 2015 amendment language, which said if the person fails to perform the contract and doesn't make a refund or finish the job when the owner asks them to, then they can be criminally liable. That's criminalizing breach of contract. And there are 2 recent trial court level decisions in Vermont that have determined that that is a violation of the 13th Amendment. We'll talk more about that in a second. But so what S-183 does in making this change is that it replaces that language that these trial court decisions have found poses a constitutional issue, and it returns to the language in the pre-2015 amendment. So a person commits the offense of home improvement or land improvement fraud when they knowingly enter into a contract The key here is knowingly entering into the contract. You have to have knowledge at the time you're making the contract that you are not going to perform it. The key holding of the Supreme Court precedents that these Vermont trial court decisions were relying on for the 13th Amendment problem was that you have to require that a prosecutor show intent to defraud at the time of contract. You can't just criminalize someone from not completing a contract. The reason for that is if you are criminalizing breach of contract, you're effectively imposing criminal punishment or requiring someone to work under threat of criminal punishment, which these Supreme Court decisions have found violates the 13th Amendment's prohibition against indentured servitude. Those decisions are older. They were really looking at kind of post-Civil War laws that effectively advanced money to former enslaved persons and then threatened them with criminal punishment for not staying and working off a debt. Home improvement and land improvement fraud are a different context, but there's a New York and a Wisconsin decision in the 80s or the 90s applying that same logic. And these two trial court decisions have found the same. The Vermont Supreme Court has not weighed in yet. One of the trial court decisions is on appeal, so there will be a ruling forthcoming at some point. But S-183 avoids a potential issue by adding knowingly on line 7 to require knowledge at the time of entering into the contract, and by replacing lines 13 through 20 with the language on 20 to 21 returns to criminalizing fraud in entering into the contract instead of breaching the contract. So as amended, the statute would read that the person has to knowingly promise performance that the person does not intend to perform or knows will not be performed in whole or in part. That's the first big change. Any questions about that before I touch on the second one?
Questions? No, it seems straightforward. Thank you.
All right. The second one shows up in several places. So anytime that the statute refers to a contract or agreement, it now also refers to a change order. So as I mentioned, a change order is a kind of contract, right? It's like an additional or modification of a contract when you decide to modify whatever home or land improvement you originally contracted for. Adding change order clarifies that intent to defraud at the time you enter into a change order is also grounds for criminal liability under home or land improvement fraud. So you'll see that on page 2, line 8, page 2, line 10, and page 3, lines 2, 6, and 7. S-183 adds change order where the statute refers to contract or agreement. That's my short and sweet version of a walkthrough. Happy to talk more about anything I had mentioned or answer any questions.
I have just a quick question. I think that on page 2, line 7, you said that it was important to add knowingly there. I'm wondering why, if it's also included on line 12, not suggesting taking out, just wondering what the thinking was there.
It's a great question. The trial court decisions in interpreting the existing statute to find a 13th Amendment issue relied on a couple things, but one of them was the fact that the 2015 amendments removed knowingly where it is now added back in. I think there's an argument that as amended, these two knowinglys are doing pretty similar work, right? That you knowingly enter into a contract and you knowingly promise performance that you do not intend to perform. That if you're promising performance that is also, if you're knowingly promising performance that is at the time you are entering into the contract. So I think that first knowingly is like an abundance of caution, belt and suspenders. Like you really have to require intent to defraud at the time that you're entering into the contract. But it's a fair point and a question I have also asked myself.
Because I just read that on line 7, I read that knowingly as like that is applying to the entering into a contract.
I guess one other way to answer it is that adding it both on line 7 and on line 12 for purposes of the things that follow is that you are very clearly attaching the knowingly scienter to both elements, right? You're attaching it to the requirement that there be a contract. You're knowingly entering into a contract. It's, you know, that a contract will result and you will be bound by what you've promised to do. And you're also knowingly promising to do something that you don't intend to finish in whole or in part. So I think abundance of caution, but I appreciate the question.
Any other questions for him? It's relatively straightforward, and I will note that Representative Joanne Briano was right when he voted against this because of criminal contract. I won't admit this on record. I've already admitted this to Joel.
I will say that I was happy to learn that it was the 2015 change that actually caused the problem. Like, it
Oh,
wasn't
but we
just
did it on the,
our
well, no, it's
years
this,
ago.
no, it was our fault too.
Okay.
We extended this to land improvement as well.
Yeah, right,
So we
right.
Had the opportunity to.
Yeah.
Fix it then.
Yeah.
But the initial issues were not introduced in 2024.
We just extended that.
All right, so thank you, and if Matt Valeri can join us next. Matt, thank you for being here.
No problem. I don't really need to look at this. I'm not the Lair Defender General. I was here in 2003 when the original version was passed. And I was here in 2015 when the next version was passed. And I said in 2015 exactly what is being discussed now, in addition to some other reasons why traditionally the criminal law does not create strict liability crimes for civil violations, civil penalties for breach of contract. This is, and I'm sure he's smiling down on me at this point, this is one of the Senator Sears bills that we referred to as what happened to Dick Sears' mother ends up in a bill. And there's some number of these, including, you know, telecommunication fraud and mail. So there's a group of these sort of things where elderly people are taken advantage of, and they ended up in bills like this. And in 2015, when this came back, what part of what the issue was that the Attorney General's office had difficulty proving cases of intentional fraud, but fraud is an intentional crime under common law and under the Model Penal Code, and it was under our current statutory scheme. So, you know, there are multiple ways to look at this issue. One is that, and you also should have some understanding of how these crimes are, this activity, which gave rise to a crime, comes up in business. People, contractors will routinely go into jobs fully intending on completing the job, but they have multiple jobs going on. Somewhere they might be a subcontractor or the like, and somewhere along the way somebody doesn't pay them. And because they're working off of credit lines and the like, sometimes the banks will revoke a credit line, and now they don't have the cash available to finish the job that they had bid originally. And they don't have the means to remedy the situation after the fact. Now they went into the deal fully intending to complete the job, but circumstances beyond their control after the fact change, and now they don't have the ability to complete the job, either from a materials point of view or from being able to pay workers who work for them. What the bill did in 2015, which became law, is effectively say we don't care about outside factors that give rise to your breach. Just the fact that you have a breach and you cannot fix it results in a potential criminal penalty. You also have contractors out there who are, to be frank, incompetent, and they don't know how to bid their jobs. They don't understand their expenses. They think they can get it done cheaper than they can, and they really want the job. And then they get in the middle of it and realize they can't finish. Now that is negligence, but it's typically not criminal. But what, again, the bill in 15 that became law did is said, we don't really care what your reasons are. We're making this a crime. The courts, when they were looking at these, and I predicted this at the time, we're not going to allow people to be forced to work when they had no ability to comply, number one, and people are going to end up kind of on this list of, when you get a criminal conviction for contractor fraud, where traditionally the common law and model penal code doesn't treat this activity as criminal. So, it's some number of years later, now over a decade after it was originally passed, but, I guess I hate to say, well, I told you so, but I told you so.
You love to say that.
Yeah, well, the thing is, you got to stick around as long as I've been here for the last 25 years to be able to do it. If I wasn't here at the time, probably I'd be sitting in my living room saying, I told them so. But I get to do it here. And so that's kind of interesting. In any event, this isn't a bill to me that does anything but kind of go back to what traditional common law and criminal law identifies as criminal activity, where people are intending to effectively steal from somebody, they have bad intent going into the deal, that they take somebody's money and run away with it. Those things are not easy to prove, but crimes should not be easy to prove. There's another system of justice, the civil justice system, that deals with breaches of contract, and that's not always satisfactory. And it does put a burden on the homeowner, landowner, to be diligent in understanding, maybe you need a bond, maybe you need to make sure that there's a credit line available, maybe you need to research your contractor and not just believe the person who shows up at your door and says, hey, I can do your siding for X amount of dollars. And it sounds like such a good deal. Why wouldn't you do it? But it is the bill as it's written, and as it kind of reverting to what it was previously, recognizes the realities of business, and recognizes the tradition in criminal law where if people aren't intentionally trying to take somebody's money or defraud them, it's not a crime. I would, by the way, not take out the intentional and knowingly in either section, because I think it makes it abundantly clear. And lawyers, where you have even a little gap, it's opening for litigating one word. And we do it all the time. And it's to the clearer you can make it, the better. I don't think it harms anything by having it in there, and you don't have to infer that it, the knowingly carries through the statute. It's easy enough to keep it the way it is. So, I support the bill. It is not a huge burden on the public defense system or the criminal justice system as a whole, but it just seems to me, even notwithstanding the 13th Amendment issues that have been raised by the court as kind of the vehicle to get to this point, is that it's fair to those who in good faith enter into contracts that end up going south somewhere in the middle, where I'm sure that folks would just soon finish their contracts, but we don't solve those problems with the criminal law traditionally. We solve them with civil law and negligence law, breach of contract, and maybe even consumer fraud on the civil side. I used to do a lot of those cases in the years I was in private practice. At one point, I was actually, I believe, considered somewhat of an expert in it. And those were pretty effective, where you had somebody who wanted to continue their contractor business in getting results. But it wasn't criminal. It doesn't rise to the level of something where jail or fines or probation or the like was the appropriate resolution. Because frankly, it doesn't get the job done any better than the civil system does. And the civil system has, its limitations as well, even if you get a judgment. But this is not traditionally a criminal area, but it escalated to that level because, there was an issue with it. It wasn't. I thought it was covered by other law, which I think it was. But that having been said, the change in 15 was really the result of the Attorney General's office at the time saying this was difficult to prove, and it is, and crime should be. So that's pretty much my testimony.
Okay.
And this is pure curiosity, you may not have the answer to, but the Supreme Court case that led to being found unconstitutional, I'm curious if it was land improvement or home improvement.
Well, these were both trial court in Vermont.
But
The ones from the 80s and the 90s from other states. I was familiar with them at the time because it was part of the argument in 2015. But both of these in Vermont were trial court decisions.
we know if they were the land or the land.
And I don't really usually most of the ones that went up had been litigated have not been land fraud. They've been contractor building.
Yes, the late 19th century, early 20th Supreme Court cases that these recent Vermont trial court cases are relying on aren't really home improvement or land improvement fraud statutes. They're statutes that say if you are a laborer and you promise to do work on someone's land, I think generally agricultural.
Yeah.
And you get an advance and you don't pay it back, that can be grounds for criminal liability. So I guess if you have to classify it, it'd be an improvement, but that's not really how those statutes were used at the time.
Some of these land improvement ones, if I remember the testimony from 11 years ago, really had to do with like a lot of logging type stuff. We have a separate logging statute as well that also has like a civil penalty 3 times stump value or something for wrongfully cutting trees, and they were kind of intermeshed together when this was being discussed. I don't know that it makes that much difference, but these usually were kind of trying to deal with the folks who are coming door to door saying, hey, I'll paint your house for $2,500. I need $1,000 down. And, they show up for one day, splatter some paint, never show up again. Thanks for the other $900 that we just put in our pocket, that kind of thing. That's really what was, I think they were looking at. There are giant breaches by big companies that lose their credit lines and that kind of thing because a sub doesn't, somebody doesn't pay them, that kind of thing. That happens in business all the time. Interestingly, we don't usually go after those guys. It's usually the little guys that get subject to this.
Any other questions from that? All right, this one seems straightforward. It's good to have a bill that you can fully support. I like.
We'll see what happens. No, there's something wrong with this one.
All right.
Thank you.
Thank you very much, Matt. So we're going to shift to 657 because Angela is going to be presenting a amendment to House Human Services, so just really quickly, a week and a half or so ago, we had some testimony on this, and frankly, I thought that we had closed the loop on what our recommendations were to House Human Services. There was some tweaking of language for clarity that they made in an amendment, but actually I was mistaken. We hadn't closed the loop on the immunity for liability issue, which I wasn't here. I was presenting to House Appropriations, so I didn't realize that that was still an open issue. But with that, I will turn it over to Angela if you just kind of explain where we are with this. Really, it's clarifying language more than anything else.
Yes, if there were something we could call it other than an amendment, it might be more appropriate. It's really, but anyway, if folks recall, I think we had Adam McCrasten testify on behalf of the plaintiff's attorneys, and there was some concern about the language being potentially being a bit too broad, the immunity provision being a bit broad. And I can read the difference if folks want to hear. So in the bill that passed on second reading that we heard, it's on page 9 of draft 8.1. Immunity from liability said any entity, provider, or healthcare professional who contracts with a certified, an unaccompanied youth pursuant to this section shall be immune from liability for the determination to contract with a minor unless the entity, provider, or healthcare professional acted with gross negligence. So the amendment proposes using more specific language that really gets at, as Alleged Counsel Attorney Katie McGlynn explained or phrased it for me, it really is more specific to the purpose of the bill. So it's just saying, as you can see, an entity, provider, healthcare professional who relies in good faith on a certification form presented by a person who claims to be a certified unaccompanied youth pursuant to this section shall be immune from liability for such reliance unless they act with gross negligence. So it's just much more specific language to balance that, the necessary protections so that providers feel, safe, comfortable entering into the various forms of contracts and service provision that's stipulated in the bill, but also that youth who may be harmed still have the ability to seek damages for any real negligence. That's the first one. And then the interestingly, the conversation we were just having about 183 sort of relevant to this second instance of amendment. So this instance of amendment comes from existing statute. This language was not touched in 657, but the keen eye or set of eyes, pair of eyes at the Office of the Child, Youth, and Family Advocate realized that the existing statute in 13 VSA 1311 was potentially exempting shelter providers from something we did not want to exempt them from. So in 13 VSA 1311, it says that, let's see, I'm going to read just some more. So a person commits the crime of unlawfully sheltering or aiding a runaway child if, and then it's 3 things: knowingly shelters a runaway child, intentionally aids, assists a child to become a runaway, or 3, knowingly takes, entices, or harbors a runaway child with the intent of committing a criminal act involving the child or with the intent of enticing or forcing the child to commit a criminal act. Then just one line down, it says exempt from the prohibitions are shelter directors, agents, employees of a shelter, person who's taken a child into custody. So, inadvertently, that broad exemption said that shelter directors or a person who takes a child into custody is not prohibited from taking, enticing, or harboring a runaway child with the intent of committing a criminal act or involving a child or with the intent of enticing or forcing the child into a criminal act. So this amendment changes that and says these folks are exempt from the prohibitions of subdivision B1 and B2 which is just knowingly shelters a runaway child or intentionally aids, helps, or assists a child to become a runaway child, but will not be exempt from the prohibition against taking a child with the intent of committing a criminal act,
Makes sense.
which we don't want them to be exempt from.
No, yeah, right.
That's the amendment.
The question, so this is kind of, I mean, the second thing is just something that was picked up on, which it just seemed
Right.
very clear that
That was-
fix is necessary and it happens to be being put into this amendment.
Correct. Because we're, the bill, obviously, the bill is addressing this section 13 VSA 1311, this section of statute, so might as well fix it while we're in there.
Right, and the immediate part, from what I handle, I wasn't here for the testimony, there was, could have been some clarification is what the discussion was around the table, and this does that clarification. Is that correct? Okay.
That's
I mean, so I think it's just if, unless anybody has an objection to this, I don't think we need to have a straw poll for this. These are really two clarifying bits, but I just wanted to make sure everybody heard, since it did come out in the conversation that was a couple weeks ago. Anything else on this? All right, so we will, in this case, we'll take a break for 15 minutes and we'll get to Andrew and Todd Villalobos, and we have one other witness. And I am reaching out to see if I can get the other couple people in on the chloride salt bill.
Yep.
Still this afternoon, because I think we'll have, well, plenty, we should probably have plenty of time to do that. So we